كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillah, Allah subhanahu wa ta'ala has given us the ability to reach the 15th. This is the final lesson for this semester. And as you know, that these lectures are being provided by White Thread Institute and for the Wise University. And inshallah, Allah make your journey easy. So let us begin. There's a few more things that we have to cover regarding Kitabu Adab al-Qadi. And then after that, I have something else to inshallah share with you, and then we will end this semester inshallah, and we'll see you inshallah. So what we're going to be covering today is, as I promised you in the last session, we're going to be discussing the arbitrator that's appointed by individuals or two parties, how they go about it, what's their scope and so on, and then what they're allowed to do and what they're not allowed to. Pretty much that's what this discussion is about today, inshallah. So Imam Quduri says, وَإِذَا حَكَّمَ رَجُلَانِ مُتَدَاعِيَانِ رَجُلًا لِيَحْكُمَ بَيْنَهُمَا وَرَضِيَ بِحُكْمِهِ فَحَكَمَ بَيْنَهُمَا جَازَ. If two claimants, so they're both claiming something, right? They've both got a dispute about something. So he makes them out to be both claimants in a sense. If they appoint another third individual to judge between them and they express their satisfaction with his judgment, and then he judges between them, jaza, is permissible. Usually, لِأَنَّ لَهُمَا وِلَايَةً عَلَى أَنفُسِهِمَا. Why? Because they have authority over themselves, right? To accept a right, to confess to a right or whatever. فَصَحَّ تَحْكِيمُهُمَا. Right? So obviously if they can impose things on themselves, they're allowed to consign that discretion to somebody else. Okay, you know what? We can't decide between them. We need to get this sorted out. We don't want to go to the judge. That just becomes too complicated or whatever, right? Dates are, it takes too long. Let's just get this guy. He's a decent guy, this sheikh, this elder in our community or whatever it is, and let's just go by him, right? وَيَنْفُذُ حُكْمُهُ عَلَيْهِمَا. And he says that his judgment over them will be implementable, right? So they are bound between them and Allah subhanahu wa ta'ala then to take his judgment. Okay? So that was briefly speaking. However, then it says, إِذَا كَانَ الْمُحَكَّمْ بِصِفَةِ الْحَاكِمِ. As long as the person that they have appointed as the arbitrator has the characteristics that a judge should have, right? فَيُشْتَرَطُ فِيهِ مَا يُشْتَرَطْ فِي الْقَاضِي. Now he has to follow the same thing. All the conditions that are stipulated for a judge are stipulated for him as well, right? So he'd have to go and read this chapter or take this lesson essentially and understand the basics of that. And then he says, okay, so now to expand on this, now what I would suggest is if anybody is ever wanting to do this, then rather than verbally, because I've been in this case a number of times, either myself or somebody else is made the judge to arbitrator. So the best way to do this is to essentially write up a document to say that so-and-so and so-and-so, or this party and that party, this family and this family, they have made so-and-so the arbitrator between them, and they are all willing to accept his judgment after he listens to both parties, and it's going to be on this day that they're going to do the session, and then have every member sign that. I've had cases where they do that and then after that they don't take it seriously, but bound to take it seriously afterwards between them and Allah subhanahu wa ta'ala, otherwise they could be sinful. Right, because ultimately they're putting this person into that position. They then have to accept it. Anyway, let's carry on. He gives a number of rulings regarding this. وَلَا يَجُوزُ تَحْكِيمُ الْكَافِرِ الْحَرْبِ. They're not allowed to, Muslims would not be allowed to designate a non-Muslim harbi, which means the person from an enemy state, right? That's a clarification that Imam Maydani makes. وَالْعَبْدِ or a slave at all. So this would not be allowed at all. وَالذِّمِّ, neither can they make an arbitrator a person who is of another faith in their own country, even if he's not from another state, even if he's from the Darul Islam, but he's not a Muslim. A dhimmi, what they say, ahlu dhimma, they're not allowed to make them either, because this is a question of wilayah. This is a very formal issue. Yes, maybe the guy can give him suggestions or whatever, but in terms of an authority-wise, that is divinely acceptable and implementable and divinely observable, then no, they can't do that. Illa an yuhakkimahu dhimmiyan. Yes, if there are people of that same faith within the country, two dhimmis, Christians or Jews or a person of any other faith that remains in an Islamic state, they can make somebody of a different faith an arbitrator between them. لأنه من أهل الشهادة عليهم, because such a person, as we read earlier in the previous chapter, can also give testimony and be proof for him, right? Likewise, they can't make mahdudi fil qadhf. I've discussed that before. The person who was guilty of slandering somebody, who couldn't bring proof, then forever he becomes somebody who can never bear witness in court, right? Somebody who's dropped in that sense. So that person can't be made an arbitrator as well. Wa in taba, even if he's made tawbah, okay, he doesn't have any sin anymore, but he loses that position and that possibility of position. Likewise, they can't make a fasik a transgressor. Likewise, they can't make a child, because these people just don't have the capacity to have to that judgment, اعتبارا بأهل الشهادة, just the way that they would not be allowed to do shahada either. This is the case of, you're not allowed to make somebody like that. Whether if a person is made like that, whether and then they give a judgment, whether that will be acceptable or not, that's a different case. But this is saying that you're not allowed. So some of these would be that you're not allowed at all, and they can't even give a judgment like the non-Muslim. However, there will be some of these, as we discussed in the fasik, that in some cases, even if they are made, then sometimes it may be implementable. That's why Imam Marghidani in the Hidayah says, وَالْفَاسِقُ إِذَا حُكِّمَ, that a fasik, if he is made an arbitrator, right, يجب أن يجوز عندنا, then it's necessary that should be permissible. Meaning, it's not a good idea, but if it's done, then it will be valid, and they would have to listen to him. كما مر في المولى, as the discussion has already passed when we discussed the official judge as well. Okay. ولكل واحد من المحكمين له أن يرجع عن تحكيمه لأنه مقلد من جهتهما فلا يحكم إلا برضاهما جميعا. ولكل واحد من المحكمين له, yes, أن يرجع. Now, let's just say the two parties decided that we're going to make X person the arbitrator. Before anything could be done, one of them pulls out, or both of them pull out. That's fine. They can do that. That just means that it won't go through anymore. So it's not binding. Once it only becomes binding to accept what he says after he makes a judgment. Before the judgment, they're the ones who set him up to be the judge, to be the arbitrator. They can cancel it. He only has the capacity as long as they're the one making it. So if they pull out, then it's pulled out from under him. He no longer is in a position of arbitrator. Arbitrator is only as good as the people around them trust them and let them be the arbitrator. And وَذَلِكَ مَا لَمْ, so even if one of them pulls out, then there's nothing, because this requires both. وَلِكُلِّ وَاحِدٍ مِنْ وَذَلِكَ مَا لَمْ يَحْكُمْ عَلَيْهِمَا. This is obviously until he makes the judgment. They can pull out before that. Once he makes the judgment, then they can't say, hey, no. That's as I've seen people do that, unfortunately. They trust somebody to do it, they appoint somebody to do it, and then they pull out afterwards when it doesn't go according to them. And that's going to be obvious. He can't judge according to what both would like, would he? Because if that's the case, then they would have already made that kind of judgment. It's going to go against one, it's going to be favor the other person, or somewhere in that area. So somebody's going to be unhappy. فَإِذَا حَكَمَ عَلَيْهِمَا وَهُمَا عَلَى تَحْكِيمِهِمَا. So once he does give a judgment for them, against them, for them, and they had not pulled the arbitration back, لزمهما الحكم, that judgment becomes binding on them, لصدوره عن ولاية عليهما, because it has been issued from a place of authority over them, because they had made that, given him that authority. So it's their own doing. وَإِذَا رُفِعَ حُكْمُهُ أي حُكْمُ الْمُحَكَّمِ الْقَاضِي. However, if they take that judgment, or somebody takes that judgment to a proper judge, official judge, formal judge, فَوَافَقَ مَذْهَبَهُ, and it goes in accordance to what his opinion would be as well, أَمْضَاهُ, he can implement that. Right, he can implement that. لأنه لا فائدة في نقضه. Why should he break it? That's what he would have made a judgment. That's the judgment he would have had as well. So why? What's the benefit of cancelling that out or breaking it? ثم إبرامه على هذا الوجه, and then to redo it. There's no point. Yes, it's fine. Let us. So now it will actually become a official judgment because he has ratified it. وإن خالف وخالف رأيه. However, if it goes against his opinion, أبطله, he can cancel it out. This is very different from the case where there was a prior judgment given by another judge. This guy couldn't cancel it unless it was completely against the Quran, Sunnah, etc. Right? This is, even if it's in accordance with Quran and Sunnah, but it's a different opinion and it's against his opinion, then he can actually cancel this one. لأن حكمه لا يلزمه, because that arbitrator's judgment is not binding on him. لعدم التحكيم منه, because he did not make him a judge. أي لأن حكم المحكم لا يتعدى المحكمين, essentially saying that the arbitrator's judgment can't go beyond the two parties that make him the judge. It doesn't go beyond that. It doesn't have any scope or effect beyond that. Right? That's quite clear. عدم جواز التحكيم في الحدود. Now, such an arbitration is not allowed. ولا يجوز التحكيم في الحدود والقصاص. It is not allowed in the cases of hudud and qisas. Because those are serious issues. They have to be done by the state. You can't have like a guy who drank and there's somebody else who charge him, and then they say, you know what, let's go and let them do it. And the person who has drank intoxicant really wants to have the had applied to him. There are some people like that. I've come across 2 or 3 people like that in my life, where they've written to me or asked me that I've committed zina and I would actually like to be flogged. Or another one was married, I'd like, and I said, look, in this country there's no such thing, because nobody can do this individually as an arbitrator. If you were in a Muslim land where this kind of things happen, there might be a different story, but I can't help you here with this, because there's no Islamic state here. So these are things that only the state can do, or a judge can do that. There are multiple ways of establishing judges, right? So it doesn't have to be through an Islamic. There is a view that you can establish a judge by consensus of a group of Muslims. So there is that discussion that if a group of Muslims, they decide in a non-Muslim land where there's no state appointed Muslim judges as such. I mean, there may be state appointed Muslim judges in the secular system, but there won't be like a Muslim court, because that they're not going to have a Muslim court. Most of these countries very frightened of that, and so on. Although there are some countries which allow that, right? Which would allow that, to have a Muslim court, just like Muslims allowed Christians to have their own court and their own arbitrators, their own judges, right, for their matters, for their specific matters in some cases. Anyway, so there is an opinion that a group of Muslims can get together and appoint even in non-Muslim countries, appoint a judge system like the Imara Sharia has done in India, which is supposed to be officially a secular country, majority Hindu, majority non-Muslim, you can say, but they've allowed judges, and that judge has certain powers only. Obviously, they have to work within the law of the country, so they don't have, they can't go and imprison somebody. It's usually to do with talaq issues, nikah issues, khula issues, business arbitration issues, but they usually don't have what they call the power of imposition. That's the thing. But they can do whatever is divinely between them and Allah subhanahu wa ta'ala, between people and Allah subhanahu wa ta'ala, they can speak about those kind of things. So it's kind of you can say a limited form of qada in non-Muslim countries. So anyway, you can't have hudud and qisas through an arbitration like that. That has to be taken through the proper state sponsored, and whether that secondary form of qada I spoke about in non-Muslim countries, whether they could implement something like that, that would remain to be seen. That would obviously be based on the law of the land and so on. But yeah, it has to be a proper qada system for hudud and qisas to be established, because, and the reason is very simple. This individual that they might be putting up that, okay, we fornicated, I want you to judge between us and then give us a flogging or whatever, for example, right? A person doesn't have a right to even do that on themselves, because this is about punishing them. This is about taking their blood, for example, taking a limb for a limb. A person doesn't have a right to do that even himself. Like if person A cuts off person B's limb, he can't then say in retaliation, I'm just going to cut off my own limb for you. You're not allowed to do that. That's not within a person's right, even on his own body, from his own body. That's why they would not be able to give that authority to somebody else to do. But yeah, if it's a financial penalty, then yeah, people can take on financial penalties, financial obligations. That's not a problem. Okay. Anyway, the scholars have said that because Imam Quduri has mentioned that it's not allowed to set an arbitrator for hudud and qisas, that's the only exception he's making. It means that for anything else, it should be a fine to designate and to appoint a arbitrator for that. Except that we're usually not going to give a fatwa in that regard. ويقال يحتاج إلى حكم المولى دفعا لتجاسر العوام, because we just don't want people to take matters in their own hands. So it's not a fatwa we're going to give or encourage people to do that. Yes, in certain cases a scholar would be able to deal with certain financial issues, but anything beyond that, or certain nikah issues or some other conflict issues, some family conflicts, that doesn't have to go to court maybe, but we don't want this to be taken out of the hands of the state, because some things are just best left in the hands of a good state, right? When people start taking it over, it just causes a big problem. For example, in COVID, there was an allowance given, which is permissible, but that Jumu'ah can be performed in houses or shops as long as there's a minimum number of people. In the Hanafi school is only 4 people or something, whereas in the Shafi'i school is 40, so Shafi'i is difficult for that. Now after COVID is gone, time COVID when masjids were closed, people had to do that, to do Jumu'ah somewhere. Now people are lazy, so they get their few employees, 5 employees, and they just do Jumu'ah in their shop, in their store or whatever, and then they don't go to the masjid. And that they're missing out on something very, very important. So that's certain things that might be permissible, but giving a general permission or encouragement for them creates a problem in the spirit of the Sharia, though it may be according to the letter of the law but not according to the spirit of the law. Okay, then he says, okay, let's finish this quickly. وَإِن حَكَّمَ رَجُلًا فِي دَمِ خَطَئٍ, if they set an arbitrator, if they designate an arbitrator with regards to a mistaken homicide, right? فَقَضَى الْحَكَمُ الْمُحَكَّمُ بِالدِّيَةِ عَلَى الْعَاقِلَةِ لَمْ يَنْفُذْ حُكْمُهُ. So even in that case, it's not allowed. He made a judgment that they would have to pay a ransom, right, for the family of the murdered one. His hukum will not be implementable in this regard, because again, he doesn't have the right to do that, because in this case the other family didn't even make him the arbitrator. Okay, لأنه لا تحكيم من جهة, because the family did not, the 2 individuals might have, but the full family did not make him the arbitrator. And yeah, it can only be for the parties that he is dealing with, that have made him the arbitrator. ويجوز للمحكم أن يسمع البينة ويقضي بالنكول والإقرار لأنه حكم موافق للشرع. Anyway, going into what he can do. So if it's a very straightforward case that doesn't involve any of these sensitive matters that are not allowed, right? Like just a monetary issue of some basic conflict of who owes who money, etc., land issues, so on. Anyway, it's permissible for this arbitrator to now listen to the case, listen to the lawsuit, listen to the witnesses, and then give a judgment, even based on, he turns around to the defendant, and the defendant says, no, I'm not willing to swear an oath, right? So he can give a judgment. So he follows the same procedure, right? وحكم الحاكم مطلقا لأبويه وإن علوا ووالده وإن سفر وزوجته باطل. Now this is going back to whether it's the arbitrator or the proper judge, is saying that the judgment of a judge, any judgment in fact, for his father, for his parents, sorry, وَإِنْ عَلَوْا, which means even if it's his grandparents or great-grandparents and above, وَوَلَدِهِ, or his children or grandchildren and so on, and thereafter, or his wife or her husband, right? باطل, invalid completely. You can't give a judgment, any judgment, mutlaqan, he says, just as you can't bear witness for them in their favor, or definitely not in their favor. So it's not allowed. It would be completely invalid. لأنه لا تقبل شهادته لهؤلاء, because as we said before, even his witness for them is not allowed. لمكان التهمة, because of the possibility of there being suspicion, their conflict of interest. فلا يصح القضاء لهم, so it would be invalid for him to make a judgment in their favor. Okay, so this is anything to do in their favor that would be completely disallowed. However, look at this. It says بخلاف ما إذا حكم عليهم. Yes, if there was a judgment where he ended up making a judgment against them, not in their favor, but in favor of their opponent, لأنه تقبل شهادة عليهم, that would be allowed. Because his witnessing against them for their adversary would be allowed, because there's no suspicion in that regard. There's no conflict of interest, right? There's no conflict of interest. That's just kind of doesn't sound right, right? That the person is doing that. But if he's a just person and he did it that way, then it would be fine. But even if he was just and everything, and in reality, and the justice was for his parents or for his children, he's not allowed to make that judgment. Even though he's completely just, another judge can do it, he's not allowed to do that. But, so it's kind of like, do I take this case? Don't I take this case? If he knows that they're wrong anyway, he will, if he took the case, and he knows they're wrong anyways, that's why he took the case, and then he judged against them. Okay, that's probably, I'm just looking at this practically, that where would that be? Where would that come about? But because he'd probably have some prior information, if it's his own children or parents, he would have some prior information, he'd have some idea whether they're guilty or not. So that could decide whether, to follow this, whether he needs to take on this case or not. So if he knows that, no, they're wrong, I want to set this right, I want to do the right thing. So he takes the case and he judges against them. Okay, fine. Because it says, because there's no conflict of interest there. There's not going to be any suspicion in that regard. فَكَذَا الْقَضَاء, so likewise the judgment would be allowed, just like his witnessing would be allowed against them. But if it's for them, he doesn't take that case. It wouldn't even be allowed. Even if he did end up taking the case, somebody else would have to deal with it. What we're going to cover now, to round this off, round this whole these lessons off, is the difference, because we were discussing this a bit earlier, the difference when they said that in some cases it will turn out to be a fatwa rather than a judgment. So I want to just discuss quickly, what is a fatwa? A fatwa is seen more as a non-binding advisory opinion, usually to an individual. But sometimes, we said earlier that sometimes if the mufti, or rather the judge, is not very competent, right, he can have a team of muftis with him. So a mufti can provide a fatwa to a judge or any other questioner seeking a ruling. So we have to understand a fatwa. So formulating a fatwa is the prerogative of a jurist, or more specifically a jurisconsult or a mufti, right? Now, the position of the mufti or the jurist issuing fatwas has historically been mostly informal and without political affiliation. The judge, on the other hand, is always a political appointment in the sense that it's with the state, it's with the it doesn't mean it's political in the sense that they have to play politics with it, but it means that a judge has to be established, as we've just discussed in the previous portion, that you can have an arbitrator, but to have a proper judge, it needs to be state appointed, unless a group of Muslimin in a non-Muslim, and then they will have certain restrictions and so on. So a mufti, on the other hand, is anybody can give a fatwa, right? However, when we say it's been mostly an informal, right, position, is because jurists are sometimes, in some countries, are officially appointed as muftis. So some countries have official muftis, whereas other countries don't have any official muftis, but lots of unofficial muftis that are very capable and competent. So mufti essentially is somebody who gives a fatwa, who tells you especially complicated rulings. That's a mufti. However, in some countries, they've just taken mufti as the head of the Islamic community, right? Sometimes I know one mufti of one country, a non-Muslim country, but for the Muslims of that country, which are about 20-25% of the country, he doesn't know Arabic and he doesn't know English, but he doesn't know Arabic, and he's the mufti, not because he's very, very learned, but because he's probably the best person for leading the Muslim community. So the word mufti can have multiple, but the real meaning of mufti is the person who gives fatwas. So in some countries they have an official position, like the muftis of Bosnia, Albania, Egypt, Syria, and Saudi Arabia. And usually in these countries, those muftis will be knowledgeable as well, at least to some level. Then you can have, then there was the case of the Ottoman Mufti of Istanbul, known as Shaykh al-Islam under the Ottomans. Muftis were also appointed as legal consultants to the judiciary, as we said earlier. Now, I'm reading all of this, and you can go ahead and find this online. It's from my thesis, my PhD thesis, my PhD research on Sheikh Abu Layth al-Samarkandi's Kitab al-Nawazil, which is the first fatwa collection in the Hanafi school. So if you do a search for Kitab al-Nawazil with my name, you'll probably be able to download it, where I've done a critical edition of a portion of the Kitab al-Nawazil, which is our first fatwa collection in the Hanafi school. So this is all the preliminary matter, the study on the text. So here I discuss what exactly is a mufti, and then I contrast the mufti with the judge, and I felt that that would be very useful for us to understand, since we've just talked about the role of a judge, and there was a discussion about a mufti as well. So as I said, muftis were also appointed as legal consultants to the judiciary, and at times sought out to strengthen a particular political motivation or an aspect of domestic or foreign policy. Sometimes that would be the case as well. And for you who want to follow, I'm reading from page 70 of my thesis. Okay. Due to their insight into the sacred text and their interpretive abilities, muftis will be consulted by all levels of society, from the common questioner to political authorities and the judges and qadis, and even by the rulers themselves. However, to issue fatwas, a mufti did not normally need any state opinion, but merely the recognition of the people and his peers. He could be giving fatwas all day long, but if there's nobody to listen to him and nobody to recognize him and take what he's saying, then he's wasting his time essentially, right? Unless he compiles all of that, puts it into a book form, and sometime in the future people find value in it, right? His authority would normally be commensurate to his piety. So if there's somebody who is recognized as a mufti by people, then usually that recognition will be commensurate to his piety, knowledge, juristic insight, and ability to solve problems based on the sacred sources, right? Jurists would sometimes receive authorization through their teachers or competent jurists to issue fatwas. So how does somebody have a right to issue fatwas? Usually they will be authorized by their teacher to do that, or they learn so much that when they actually start telling people rulings, they're actually taken as fatwas, even if he doesn't call them fatwas. Therefore, it was mostly a self-regulating occupation by the scholars themselves, though at times governments sought to impose some control of this activity, because it was very powerful. If they can get the mufti to support what they're saying, then, unless people then just treat that mufti as a sold out mufti, then he loses all credence. but it just makes the rulers feel good, right? This mostly independent status of muftis help to protect them from duress to issue fatwas in accordance with another's whims, rather than on their own qualified understanding of the sacred sources. Therefore, their fatwa would also sometimes be used as a tool for critics of a particular political regime against them, right? Sometimes a mufti would clearly give a fatwa against, for example, the ruling party or whoever it is. To better understand, so this is where it's probably most relevant to us, to better understand the role of a mufti, it may be useful to contrast it with the role of the qadi, the judge. The role of the qadi was mostly formal. Now you would be very knowledgeable about the qadi because we've just done that, and usually it would be an officially paid position because it's a state official he is. His judgments were considered binding decrees. The word qada itself implies that, qada, right? And backed by state enforcement. That's what a qadi has over the mufti. Unlike the informational, non-binding nature of the mufti's fatwa, right? The mufti can't implement his fatwa unless the state takes it on or the judge takes it on, does it? A qadi was appointed by the state and was not even required to be a qualified jurist, as we saw earlier. A qadi or qadis could rely on the fatwa, or a qadi could rely on the fatwa of a mufti when the need arose, right? They could rely on the fatwa of a mufti when the need arose. A qadi's task was to assess the case brought before him, determine the context of the problem, consult the mufti if there were juridical issues involved, and then adjudicate on the matter. Hence the mufti, not the qadi, was usually considered the ultimate hermeneutical authority. Yes, in some cases you had qadis that were, mashallah, very good muftis as well. All right, but that wasn't always the case. There are also other distinctions between the two roles. A mufti would normally treat the details of the case in question as given and respond accordingly without factoring out any outside detail on the contrary. A mufti takes the question and answers it. A qadi's task, though, would be to scrutinize and ascertain the veracity of the details presented him by the plaintiff and the defendant, as those purported facts were normally the issue in question. Furthermore, the judgment of a qadi is usually specific in its imposition, while the scope of a fatwa is normally more general, as it attempts to reveal the generic religious rulings. So fatwas are usually given on a generic ruling that would apply to multiple people, usually, not always, whereas a judgment of a qadi is on a very specific issue relating to certain parties. Yes, it could be broader in scope and apply to others as well. While there has not been much of a history of recording the judicial judgments given by Hanafi qadis in the Muslim lands, there are some but not many. Many fatwa collections exist, so there's lots of fatwa collections, but there's not been much of a tradition within the Hanafi school to compile and record all of the judicial judgments. These sijillat we discussed, right? We don't find too many of them. The Ottomans did some stuff, and fatwa collections, we've got lots of them, and they continue to be compiled. Another interesting distinction between the two institutions of qada and ifta is that the domain of the qadi is usually to do with matters related to the world, right? It's not about, is your salat valid or not? It's more about, he took my water, for example, right? Between the two institutions, right? So predominantly in the areas of transactions, mu'amalat, dealing, social dealings, etc., injuries, jinayat, the penal law and code, hudud, while a mufti is expected to be competent in all chapters of jurisprudence, including those and other worldly issues such as the validity of the ritual ablution and the prayer, whose accountability is divine rather than worldly. So qadis are not going to judge whether somebody's wudu was done or not, unless it was to do with a case relating to some money or something, or a deed or something like that, right? So now you understand the difference between those two roles, right? So hopefully that gives you an understanding what a mufti is and what the position of the qadi is. Usually they work together. A qadi will have multiple muftis, like they did in the Ottoman lands. They had multiple muftis, to assist junior muftis, senior muftis, etc. And yeah, so that's how it was. So alhamdulillah, my dear brothers and sisters, this is essentially the final few minutes that I have with you for this semester, inshallah. So just to round up what we've covered during this semester, alhamdulillah, we started off with the discussion of the claim itself and how the proofs work, how the procedure for all of that is. Inshallah, that becomes very clear to you now, who is allowed to do this, who's not allowed, what the lawsuit needs to look like, and so on. Then it was the discussion about the witnessing and who can be a witness, who cannot be a witness, what scope do they have, how far do they have to go, and if there's we had lots of cases of witnesses saying two different things, and whose witness is allowed for whom, where there's a conflict of interest. We discussed all of that. Then we discussed somebody coming back and revoking his witness after having given witness and pulling out. What did that do? So there was lots of these kind of things. There was a witness on a witness, and so on and so forth. Then we discussed the etiquettes or the role of a judge, what his procedures are, what he does, what he can do, what he can't do, who can be a judge, and a judgment upon a judgment, different jurisdictions. We dealt with all of that kind of stuff. So now, just to give you an idea, inshallah, in the next semester of this second year of ours, we're going to be discussing, we've alhamdulillah finished the discussion. There was the discussion of Kitab al-Ayman wa Nudhur, which is taught by one of our colleagues, which was about the oaths and so on. That's related usually to this chapter. So that was taught by our colleague, and I taught the rest of this. Now, in the next semester, we continue with the discussion of various ways of dividing assets. Kitab al-Qisma. So that's referring to division of assets and division of different things. So inshallah, we're going to cover that. We're going to then cover the different fiqh and jurisprudence related to compulsion, right? Different things that somebody might be compelled by, compelled to do. So what is the ruling of that? What are the repercussions of that, the consequences of that? We'll be dealing with that. Then we're going to be dealing with Kitab al-Siyar, right? So that was Kitab al-Ikrah. I just discussed. Kitab al-Siyar is next. This is essentially discussing jihad, the war, and how that works. What is the hukm of it? What are the types of this? How do you deal with prisoners? What is allowed in a war? What is not allowed? A very, very interesting topic, because there's so much confusion and propaganda around this. So this is quite a large chapter that discusses with a lot of that discussion, how to deal with rebels. And then, of course, there's the discussion of Kitab al-Hadr wal-Ibaha. This is kind of a catch-all chapter of the things which are prohibited and the things which are permissible. Now, usually those kind of things would have been mentioned in their own chapters, but this is kind of the independently mentioned. There's usually, this includes a discussion of what is allowed for men and women to look at, intergender relationships essentially. Then it discusses clothing and jewelry and adornment. Then it discusses food and food related halal and haram issues. And then it discusses some aspects of earning and so on. So usually those are the four major areas, broad areas that are covered in there. So inshallah, we will see you in the next semester. Allah bless you, and may Allah allow us to continue to learn and study and then teach, inshallah. We wish you the best. We pray that Allah subhanahu wa ta'ala grant you the best, and love to hear from you. So you can contact me through Zamzam Academy. I have even a phone number on there, so you can contact me through zamzamacademy.com, the contact us page. And love to hear from you, how your year is going. And Allah bless you all. And inshallah, we'll see you soon, inshallah, for the next semester. Jazakallah khairan, and assalamu alaikum. Please make dua for the Wise University and for the people who have set this up. Prince Ghazi, may Allah bless him, and for all of us at White Thread, Allah bless you all as well, and assalamu alaikum wa rahmatullahi wa barakatuh.